Breaking news! CEO of Barnet Council John Houghton resigns just 2 days after public interest disclosure. Met Police advised the victim to disclose this case publicly to protect the family from harm and prevent future harm to other families in the area. Barnet Council clearly prevented criminal investigations into employees' conduct to prevent legal accountability, resulting in perverting the course of justice and breaching a family's human rights for nearly a decade. Here you will see a clip from the disclosure that we believe caused the resignation of CEO John Houghton from Barnet Council.
Public interest disclosure, Barnet Council. In the best interests of my family and others. Barnet Council's John Houghton allows a cover-up of child exploitation to avoid legal accountability. David Tatlow, Council Monitoring Officer, until 2019 incited a crime by encouraging Lead Lado and other organisations not to fulfil their role in this case as it could possibly lead to a court case. Here is the name of the charities directly involved, along with the details of the professionals who followed David Tatlow's direction as advised by the local designated safeguarding officer.
To watch the full public disclosure, go to YouTube and search Lucy Troubles, all one word. There you will find the full disclosure and other evidence to back up the claims shown in the video. This is the notice served to CEO John Houghton when his organisation weaponised the victim's children to avoid accountability, but it backfired and will now be used as proof that the council will weaponise children to avoid legal action and prevent accountability. The notice read as follows.
To whom it may concern, John Houghton and Balwinder. Notice. You should consider this as part of the notice and demand cease and desist that will be registered and delivered to yourself within 7 days, should this situation not be immediately rectified. Currently, both my son and daughter are healthy, safe and well. The social worker was considering stepping back from the proceedings, as the children are doing great, as is confirmed with the respective school. It is my firm belief that due to me questioning a fraudulent psychological assessment, full of false copy and paste statements, your social workers have decided to continue to harass my family, causing serious alarm and distress. I have recordings of the core group meetings, which I am allowed to do as this case is in the public's interest, and the school stating they have no concerns for my children. Furthermore, the independent social worker clearly states there are no concerns regarding my parenting abilities. Therefore, I question why I am subject to pre-PLO proceedings with no due process followed and false statements clearly used. My son is now 9 years old and oblivious to how your organisation has failed to follow the CARE Act 2014, as I have protected him from the truth. Please kindly refrain from making my children fear services due to neglect and failure to act appropriately and follow due process. You have already affected my daughter and I refuse to allow repetition of effect regarding my son. I want him to grow up believing in our system and the government so he can reach his full potential and grow up with a positive attitude about the world. I intend to hold you, Mr. Houghton, and your organisation to account in a court of law for a breach of human rights, leading to extreme harassment, discrimination, and a breach of the following acts and legislation. If this behaviour and intimidation of my family using my children continues. The CARE Act 2014, the Equality Act 2010, the Harassment Act 1997, the Data Protection Act 1988, the Human Rights Act 1989, the Criminal Justice Act 2003, the UN Convention on the Rights of the Child 1989, Every Child Matters 2003, Education Act 2020, Keeping Children Safe in Education 2019, and the Children's Act 2004. My family's human rights have been breached, and this is detrimental to the children's development, which contravenes the Children's Act 2004. It does not say to continue persecuting a family for speaking out about neglect suffered from your relevant organisation. As a result of breaches of the aforementioned acts and legislation by your relevant organisation, my daughter is now very wary of social workers. My concern is that you could potentially have the same impact on my son's development, should you pursue with your current course of action. Today, I am unaware of any psychological effect on my son, apart from the effect on his level of education, due to the harassment, neglect, and breach of our human rights as mentioned below. I allege that your continued abuse of position and failure to act appropriately by allowing the production of false documents, these actions will intimately impact on my son at some point. I insist that you respectfully withdraw from any future antagonistic action towards either myself or my family members. I want the harassment of my family to stop. We need professionals that uphold the law and protect human rights, not destroy them. If you should proceed with your current course of action, I will have no alternative other than to proceed to legal redress in order to bring an immediate halt to this invidious situation. I am writing this to find a reasonable conclusion to this matter. Demand. I will be demanding the following. 1. Cease with the pre-PLO proceedings as no due process was followed and it was put in place using false documentation. 2. Stop harassing and intimidating myself using my children as weapons. 3. Stop sharing and using the fraudulent report made by Dr. Matthew Castle. 4. Stop using false information with no due process to progress through child protection and pre-PLO proceedings. 5. Stop committing fraud to try and cause me serious alarm and distress. And 6. Cease and desist in the breach of mine and my children's human rights under the following articles. Protocol Article 1. Right to peaceful enjoyment of your property. Article 2. Right to a life. Article 3. Freedom from torture and inhumane and degrading treatment. Article 6. Right to a fair trial. Article 8. Respect for our private and family life, home and correspondence. Article 9. Freedom of thought, belief and religion. Article 14. Protection from discrimination in respect of these rights and freedoms. I will be seeking legal redress against John Houghton and Barnet Capital for the action of failing to follow acts and legislation as set out above, because your organization have made claims against me with no substantial evidence. Please provide the substantiated evidence against me. If you fail to provide and substantiate the claims you have made against me in the next 7 days, I will be making a claim for redress of the false allegations made and the harm it has caused. I did not agree to anything in regards to assessment about being under duress. I was bullied and intimidated into agreeing to the assessments, as you would proceed with PLO proceedings if I did not comply, despite there being no concerns in regards to my children. It is my belief that this behavior is clear harassment, discrimination and intimidation of myself for speaking out about the neglect suffered by my family due to Barnet Council's failure to protect under the Care Act 2004. As I have been the only person protecting my children whilst all professionals with a legal duty of care have failed to do so. These actions are criminal, and I believe only arose from registering a claim in a tribunal to disclose the truth about the breaches of legislation. In the CP conference, a social worker and other professionals was advised to ensure I was getting support with my mental health and moving house. Over a period of 7 months, neither has been done. They claimed my child was taken out of school without good reason. Again, this was false. They said that I had not tried to get my son back into school, but can prove that I actively worked on getting into another school from the day I removed it. This, again, is a complete failure to follow the Care Act 2014. You cannot proceed to pre-PLOs using false information that I can prove with evidence is lies and slander to cause me and my family harm. This is fraud leading to malfeasance in public office. I have proceeded to work positively with Charlotte, a social worker, for the best interest of my children, despite seeing it as an intrusion on our lives and a clear breach of mine and my children's human rights. You are making my children fear and dislike authorities, when this is not what I want for my children to grow up experiencing. Failure to provide the substantial evidence to the claim against me, in the set amount of time above, I will view it as admittance of guilt and proceed with my claim against Mr. Houghton and your organization, as the burden of proof is on the person/organization making the claim. I am demanding that your services step back from my family and allow us to live in peace and heal from your organization's neglect and abuse, as previously requested. The only reason for your involvement moving forward is to ensure we are moved to adequate accommodation to the same standard or above to which is comparable to my current living situation, and to ensure the correct support is in place from the community mental health team if and when needed. Thank you, kind regards, Andrea O'Shaughnessy, to whom it may concern, all rights reserved.
Neither CEO John Houghton or Barnet Law's Balwinder Tank responded, and the child protection and PLO proceedings was removed. That is a clear admittance of guilt.